Welcome Donald A. Cronin. He is a partner of O'Quinn and Cronin, an attorney firm that ACCG uses. And he's going to be talking about a return to work program that he helped develop and write. So without further ado, go ahead, Donald.
Oh, thank you, Dan. Again, Donald Cronin here. If you know me, you probably know me from the HR helpline that ACCG instituted about 2 years ago. I've been managing that since January 2016. If not, and you do know me, it's probably because I represented your county when it got sued in some employment matter. And I know whether you're an HR manager or a risk manager or somewhere in between, probably the most difficult part of your job is managing both leaves of absence and the flip side to leaves of absences, which obviously is return to work. Sometimes it feels like those fact patterns manage us more than we manage them. So what we did with ACCG a couple of years ago is we came up with a return to work policy, and what I'm going to be doing here today is discussing the parameters of that return to work policy without actually referencing it. Everything I'm telling you here today is what's known as codified, that is included in the policy. But I want to talk about the return to work program from a more abstract sense to make sure we're all on the same wavelength. It's important you understand why that form policy reads the way it does so that you can decide how to modify it as you see fit. The first thing I want you to think about when we think of a return to work fact pattern is it fits into one of two categories. The first category of return to work fact patterns involve those fact patterns where the law compels us to return a medically limited employee to work. We don't have any choice, in other words. The second category involves all other return to work fact patterns. Those fact patterns where the law is silent and we as the employer get to decide when the person returns, where they return to, or even if they return. Now, there's pros and cons to both types of categories. Obviously, the negative to the first category is we don't get to decide if the employee returns. The law decides for us, which obviously is very frustrating. Part of being an employer is controlling who comes into the workplace and what they do. But the good part of the first category is we have a ready-made framework to follow. We don't have to reinvent the wheel. We know, assuming we know the law, we know what to do. The second category, obviously, the positive is we get to be an employer. We get to decide if the employee comes back to work or not. Obviously, that's part of being an employer, and it was many, many years ago the norm before Congress passed all these employment laws. The negative is there's no ready-made framework to follow. In the second category, we have to essentially create our own framework. And if we don't fill that gap with a coherent policy or philosophy or game plan, then it's very difficult to manage these fact patterns. So let's go to the first slide. Well, that is the first slide, the first substantive slide. That represents the two categories. So the first thing you have to do, and we can go to slide number 2 now, is the first part of any kind of successful return to work policy is you identifying whether or not this return to work fact pattern falls into the first category, that is the category where the law compels us to return somebody, or the second category where we have free will as an employer. And obviously, if it's in the first category, not only do we have to identify it as being in the first category, but we have to obviously follow the law. It doesn't do us any good to know the law requires a result and we ignore the law. Obviously, that would make no sense. Additionally, a successful return to work policy is going to require us to have a coherent philosophy or policy to address those fact patterns where the law doesn't compel us to do anything in particular. We need to fill in the gaps, so to speak, with a coherent policy. And I understand I'm not necessarily talking to final policymakers here today. You guys don't get to unilaterally create policy for your county or city or your authority. But nonetheless, at some point, somebody has to, in your entity, come up with a coherent philosophy to deal with these various return to work fact patterns where the law is silent and doesn't compel a particular result. And lastly, a successful return to work policy or program requires us to actually follow what we created. Obviously, it doesn't do us any good if we have this policy in place to cover the second category of return to work fact patterns if we don't follow it. So let's go to the next slide. And I want to talk about now the first category of return to work fact patterns. That is when the law compels us to return an employee back to work. And I want to start with the FMLA because a lot of employers make their lives more difficult than it has to be. As you know, under the FMLA, we have to return an employee back to the job they had before they took leave. That's the essential part of the FMLA. Well, the law provides employers a significant benefit, which is you don't have to return an employee back to work unless and until they produce a fitness for duty certification if, and this is a big if you require the employee to produce a fitness for certification requirement and you communicate that on the front end. Now, the flip side to that obviously is if you don't require your employees to produce a fitness for duty certificate upon the expiration of FMLA leave, they get to come back to the workplace. We have no control. They can be totally unable to perform their essential job functions. In that situation, we are essentially allowing the employee to be the gatekeeper. So if you work for an employer that doesn't require employees to produce a fitness for duty certificate upon their FMLA leave ending, you're going to have more fact patterns in that first category of return to work fact patterns than an employer who is actively managing these fact patterns by requiring their employees to tender a fitness for duty certificate before they're allowed to return to work. Now, it's very easy to accomplish this. If you're an employer, all you have to do on the FMLA designation form is just check on the first page, that box towards the bottom that says you will have to produce a fitness for duty certificate. And you just attach a copy of the job description. And at that point, they have to produce a fitness for duty certificate that attests they're able to perform the essential job duties, or else we don't have to return them under the FMLA. Now, the ADA will come into play eventually, but under the FMLA, we can prevent someone from coming back to work if we're proactive and we're smart. Now, one thing to mention, you cannot discriminate. If you require an employee in a job category to produce a fitness for duty certificate, all employees in that job category have to be treated the same. And you can't pick and choose. Now, the easy solution is just make everybody produce a fitness for duty certificate before coming back from FMLA leave. It makes it easier on you in terms of differentiating between employees, and it protects the county or the city, whatever you work for. In that situation, you're the gatekeeper instead of the employee. And the employee, if they have a chance to come back unhealthy, they will, because getting paid is better than sitting at home. So you don't want to give up that control.
So you could theoretically, if you were a city or a county, require a fitness for duty certificate for everybody in public works when they return, but not necessarily do that same expectation for anybody in an administrative position. Is that
is correct. Correct. But I would suggest you do it for everybody. What's the harm? They're going to their own doctor. It's not costing us anything. And someone in administrative capacity may have carpal tunnel and may not be able to do their job. So it doesn't cost us anything. If you don't require someone in administration to produce a fitness for duty certificate, what you're doing is you're letting them be the gatekeeper, which, as a matter of policy, doesn't make sense to me. I'm not here to lecture on policy. I just want to mention to you that kind of legally you're giving up that very important role if you allow somebody to come back without producing that fitness for duty certificate. So that's just something to keep in mind. Again, I know I'm not speaking to final policymakers, but that is something that I assume whoever's above you would be receptive to hearing, because everybody knows what a pain return to work and leave is. And if you have the ability to give your employer a stronger hand when it comes to FMLA, why not take that option?
Let me try and reach out to somebody and see if they have any questions thus far. Jenny Swarthwaite, are you out there? Jenny, can you hear me? Jenny, okay. Let's see this. I'm going to try Kathy. Are you at the Cassie Stansel?
Yes,
Kathy,
I'm here. Yes,
do you have any
Kathy.
questions this far?
No, not this time. Maybe later.
Okay, thank you, Kathy.
All right. So let's talk about the second fact pattern that fits into the first category of return to work fact patterns. And before I proceed, when we're talking about return to work, we're usually envisioning somebody with a temporary medical ailment. We're not contemplating somebody with a permanent physical ailment. So some of y'all may be thinking, well, why do I see ADA on this screen for? The reason you do is in 2008, the ADA was amended. And in 2008, the term disability was expanded to such a degree that it now covers temporary medical limitations and temporary medical conditions. For example, according to the EEOC, if somebody has a back impairment that prevents him or her from lifting 20 or more pounds for several months, that person is considered disabled under the ADA. So if we think about it, if we're talking about return to work, we're talking about somebody who has some sort of physical ailment that kept them out of work for some period of time. Now, obviously, if a back condition that only limits somebody from lifting 20 more pounds is a disability, if we're talking about somebody who's in a return to work scenario, we have to proceed based on the assumption, whatever that medical condition was that kept that person out of work, we're probably dealing with something that could be categorized as a disability under the ADA. So that brings us to our second fact pattern that fits into the first category, which is somebody has a medical limitation, but it doesn't affect their ability to do the job at all. That's really the essence of the ADA. Sometimes when somebody has a medical limitation, we just assume that it will impact their job, but that's not always true. So under the ADA, if somebody has a medical ailment, but it doesn't impact their ability to do the job at all, we have to return them back to work. We don't have a choice. In other words, we can't have a policy that says you don't return to work until you're perfectly healthy. Right? So that's a situation where the law compels us to return somebody who's unhealthy because their medical condition is not job related. All right. So let's go to the third fact pattern, which is on the
Before you get on to the next slide, we have a question here. We have an employee who is getting their FMLA from signed or form signed today. Can we go back and have them check the fitness box after the form is returned back to us?
All right. There's two FMLA forms that we're talking about as the employer. Typically, there's the eligibility form, which is form WH-381, and then there's the designation form WH-382. The form I'm talking about is the form you send where you formally acknowledge that leave is eligible for FMLA. That is, we are going to designate this leave as FMLA. So if I understood your question correctly, you're actually at the point where you just told them they're eligible and you're going to require them to submit a certification for purposes of determining whether they're eligible for FMLA. That's not what I'm talking about. I'm talking about on the back end, we can insist upon them submitting a fitness for duty certificate before returning to work. So to answer your question, if I understand correctly, the WH-382 form, you haven't even filled out yet. That's what you would check. Now be careful here, because if somebody in that employee's job category wasn't required to submit that fitness for duty certificate, now we have a discrimination fact pattern. So what you want to do is, instead of doing an ad hoc where from this point forward everyone has to do a fitness for duty certificate to return, I don't know if you work for a county or what entity, but the entity needs to adopt some sort of amendment to their FMLA policy to say from this point forward everybody or everybody in a particular job category will be required to submit a fitness for duty certificate. I hope I answered that question.
I think you did. As Lynn states, I think she said yes, so I think you got that.
Wonderful. So the next slide, we're talking about another ADA fact pattern. And as you should know, hopefully, there's a big difference between an essential job duty and a marginal job duty under the ADA. Under the ADA, you never have to eliminate an essential job duty from an employee's job description, whether they're disabled or not. That's a no-go. We don't ever have to go there. The flip side to that is if somebody has a disability and the disability prevents them from performing a marginal job duty, we always have to eliminate that marginal job duty to allow them to go back to work. So if an employee's medical limitation only impacts their ability to perform a marginal, that is non-essential job duty, we have to return them back to work and just eliminate those marginal job functions. Now, one thing to keep in mind here is you can easily get in trouble here by having sloppy job descriptions. If you have a job description that doesn't list an essential job duty as essential, we're going to have a lot of problems potentially. If somebody has a medical limitation that prevents them from performing that job duty, if we don't have it listed as an essential job duty on our job description, it's going to be very, very tough to maintain the argument that it's an essential job duty, because we have 100% control over our job descriptions. So if we don't have a particular duty listed under the essential job duties, it really is our fault, and it's a major problem. So just as you can protect yourself in the FMLA setting by requiring these employees to produce a fitness for duty certificate, you can also in this context protect yourself by making sure your job descriptions are very accurate. Because if they're not, then you could be obligated to permanently remove what otherwise would be an essential job duty from a person's job description.
You have a couple questions here. The first one is, I'm assuming that a fitness for duty certification would only apply in the case of someone taking a concrete block of FMLA time, not intermittent.
Generally correct, yes.
Okay.
We're talking about continuous leave. Somebody's absent for, a stretch of time, up to 12 weeks. And we're also talking about, obviously, if somebody's out because of their own medical issues, if somebody's out because of a family member, then obviously there's no fitness for duty requirement because they've already been fit. It's their family member who's ailing.
Here's another one. Do you recommend the same for out for delivery of a child or adoption?
Well, that's a matter of policy. I don't want to propose policy for you, but typically if we're dealing with childbirth and child care, I don't think there's too much concern about somebody coming back to work unable to do their job. The fact pattern I'm concerned about is somebody has a serious medical condition, serious health condition other than pregnancy, and 12 weeks is up and they're not ready to come back, but we can't prevent them from coming back. So that's really more of where I'm coming from, not so much pregnancy, but that is a policy decision. And frankly, I don't even remember if fitness for duty certificates are available for somebody in the child care context. I know for birth it would be because it's medical, but I'd have to go back and check. But that's really not what I'm contemplating. I'm contemplating the classic, somebody is injured and they can't work for some period of time.
Here's another question. Does a migraine fit into this category? She missed a lot of time due to chronic migraine. She works great when here, just can't seem to keep her here. She has threatened to take us to court if we let her go.
All right. I'm not sure if she's exhausted her FMLA or if she's even eligible. Let me go at it from both perspectives. Migraines would presumably be a serious health condition. She would be entitled to leave up to 12 weeks, whether it's intermittent, reduced duty, or continuous. If we're talking about in the ADA context, somebody's exhausted their FMLA, a migraine could or could not be. One thing you would have to do is coordinate with the entity's attorney and manage that fact pattern. We are entitled to additional information when somebody is claiming the need for leave under the ADA, and maybe that'll be a topic for a different day, but as a general rule, it's certainly a serious health condition under the FMLA in all likelihood, and very possibly a disability under the ADA, but you would have to get information from her doctor to know for sure. You wouldn't have to take her word for it. The ADA does allow you to inquire as to an employee's health status and their disability status more specifically.
So again, just to use that example from, FMLA would be pretty straightforward. They'd be given the time off. She was requested off and she'd have up to the required amount. But from an ADA, making accommodations, that would be a very difficult to make reasonable accommodations for a migraine unless there were lighting issues or other
Right.
issues related to that.
Well, and let's not forget, and this is important to mention in the context of FMLA, unpaid leave is a reasonable accommodation under the ADA, as long as it doesn't work an undue hardship on the employer. So what we would have to do in that fact pattern is we would have to be proactive. We'd have to make her go to her doctor and prove she has migraines. We'd have to get the doctor to certify what aspect of the job she's limited in, and we'd have to confer with her concerning possible reasonable accommodations. So that's a very comprehensive amount of steps you have to take. And unlike the FMLA, the ADA was never intended to cover unpaid leave. The statute doesn't even reference it, so there's not the framework in the ADA context that exists in the FMLA. So that's one of those where you really, really need to get your attorney involved to manage that fact pattern, because invariably I find employers do not get the amount of information they're entitled to under the ADA, and they're left with, you know, a puzzle that's only half completed with pieces, and it's very difficult to manage these if you don't get all the information that you're entitled to.
Here's another question regarding policy. Is it enough for the job description to list major job duties, or just it reads essential job duties?
It's probably a better practice to list essential as opposed to major. Anytime you're not using the right term of art, it creates ambiguity potentially. So I would suggest essential job duties. That's how the law is written. We can make the argument that major is essential, but why leave it up to a court to decide? Let's engage in self-help, make that essential job duties, not major job duties, and protect ourselves that way instead of hoping that major equals essential.
Can you speak to how workers' comp claims interact, or can you speak to how workers' compensation claims interact with FMLA and ADA?
Sure. Whether you're injured on the job or off the job, you're entitled to FMLA. So if we have a workers' comp fact pattern, we're going to treat that the same under the FMLA as we would if somebody was injured off the job. There's really no difference. The only difference is I find a lot of times when you guys have a workers' comp fact pattern, you're not processing it as FMLA because the employee's not asking for FMLA. You need to be aware if the employee is communicating he or she needs time off, that triggers your obligation as an employer under the FMLA to get the ball rolling, sending out the various forms and designating that leave as FMLA. But whether you're on the job or off the job, injured that is, the FMLA applies equally. In terms of the ADA actually allows you to discriminate in favor of people injured on the job. And we'll get to this hopefully towards the tail end, but under the ADA, you're allowed to create light duty jobs for people who are injured on the job and not create those light duty jobs for people who sustain non-occupational injuries. So make a long answer even longer. In the FMLA context, workers' comp really doesn't make a difference to us because it covers both employees injured on and off the job. In the ADA context, it may be very relevant if you have a policy that only calls for you to create light duty jobs for people who were injured on the job. All right, so the next slide is probably the most common fact pattern. That is, someone has a medical condition and it affects their ability to perform one or more essential job duties. If a reasonable accommodation would allow that disabled employee to perform that essential job duty, we have to return them back to work unless doing so would cause us to suffer undue hardship. So that is the essentially the category, the universe of those fact patterns in the first job category. Let me mention workers' comp before I go further. I did not include workers' comp in this category where the law compels you to return someone to work. Although the workers' comp laws create a significant economic incentive to return those folks back to work sooner rather than later, the law doesn't compel you to do that. So if you're doing that, it's because of a policy choice, not because the law forces you to return those people back to work. So if we would, let's go to the next slide. Let's just clean up here with some legal matters to consider. First rule is all of these documents relating to leave or return to work, all these medical documents, that is, They cannot be placed in the employee's personnel file. They have to be kept separate. And not only do they have to be separate from the personnel file, they either have to be in a locked file cabinet or in a locked room where only people with a need to know have access to that room. I see a lot of times where we combine the personnel file and the medical file. You can't do that. And not only can't you do it, you need to make sure the medical file is secure. And just for your information, this is not a HIPAA requirement. The ADA requires you to maintain the privacy of your employees when it comes to their medical conditions. So that's something to keep in mind. If you do have medical records in your personnel file, you need to immediately change that policy and put those in a separate file called medical folder or medical file, however you want to label it. Just understand those records cannot be kept with a personnel file. Second thing I want to address is I've seen a lot of employers with these maximum leave policies. We will allow you unpaid leave up to 12 months. Please be advised that those policies are not enforceable. And the reason for that is the ADA requires you to individually assess everybody, so you can't have a one-size-fits-all rule with respect to the amount of leave that you potentially may have to give somebody. So if you have one of those policies, just don't enforce it. You're going to have to individually assess whether or not that particular person's leave is causing undue hardship. And in some cases, it may be 6 months. 6-month leave is causing undue hardship. Other cases, maybe you can handle it for up to 18 months. So if you have a policy that purports to limit leave for a particular length of time, just please understand it's not enforceable. All right, so let's go, I think, to the last slide, or second to last slide. Now we're into category 2, the second category, where we have all these return to work fact patterns where the law doesn't tell us what to do. We get to decide as an employer. And what you decide to do is up to you. It's a matter of policy. I'm not here to advocate particular policies. I'm just here to kind of give you some suggestions to force you to confront potential policy decisions that you may want to make. And the first one is a policy question that I think everybody answers the same. Do you want to treat employees who've been injured on the job different than those employees who suffered non-occupational injuries? Just as a matter of philosophy, is that something that you guys want to do? As I mentioned, under the ADA, you can treat people injured on the job better and different than people who were injured off the job, in particular with respect to creating light duty work. So that's a philosophical question that has to be decided for your entity. The second question you may want to ponder is, do you want to place medically limited employees in positions that are currently vacant until such time as they're permanently filled? And, the question is, how qualified does the injured employee have to be for you to want to put them in that position? At what stage of the vacancy do you want to put them in there? Do you want to put them in there until interviews start and at that point not fill the position? These are all philosophical questions you guys have to recommend to probably the people above you. Another thing I want to address with you is working from home. Not being able to work is not the same as not being able to work at the workplace. There may be somebody who, for some reason, can't get to work, but they can do essentially the vast majority of their job. Do you, as a matter of policy, want to allow some of those people to work from home? Do you want to limit that work from home situation to those exempt employees, that is, those people under the FLSA who get paid salaries? Do you want to pay those people a fraction of their salary? It may be if they work from home and they get to like it and they're getting paid 100%, they don't want to go back. So maybe you want to pay them 80% of their salary if you let them work from home. Now, let me caution you, under the FMLA, if they're on FMLA leave, they can't work anywhere. What I'm addressing here is a fact pattern where someone's either not eligible for FMLA or they've already exceeded their FMLA. As a matter of policy, do you want to let people in certain situations work from home instead of being on unpaid leave? And another point I want you to contemplate, and this is in the policy as a proposed addendum, do you want to pay people on light duty 100%? If you have a job you don't like, or a job that's tough, and you're getting paid 100% to work light duty, you know what, that shoulder may feel bad for many, many months, whereas if you're only getting paid 70% or 60% of your regular salary, maybe that shoulder feels better sooner rather than later. So these are all philosophical questions that you guys have to wrestle with and recommend to whoever implements policy for your entity.
Got a couple questions, if you don't mind. One, can medical files be kept electronically in their personnel file so long as they are in a differently named folder?
You know, I don't know that. I know the ADA contemplates either in paper format, at least, in a locked file cabinet or in a locked room. My guess is if that document is accessible to a lot of people who don't need access to it, then you've got a problem. It would have to be only accessible to those people who would have a reason to know that person's medical history. And that's not a big universe of people. That's the department head, maybe the immediate supervisor, HR manager, county administrator in the county model. So possibly, but I'd be worried about more people having access to those records than otherwise should.
So it's really about access, whether it's electronic or...
It is.
Okay. Another question here. My understanding is that undue hardship is almost impossible to prove. How would that work with not limiting leave time?
All right, so it's almost impossible to prove. I wouldn't agree with that. I would agree that we never know how a court's going to rule on that. There's always ambiguity in terms of undue hardship. So in the leave context, what we're going to do is we are first going to get something from their doctor that communicates the length of the absence. You know, I've seen lots of fact patterns where it's, you know, months on end and we don't even know what we're looking at in terms of an end date. One thing we need to be is proactive and figure out what they contend they need in terms of unpaid leave. At that point, you can do an analysis by, you know, bringing the department head and asking him or her what kind of issues is this going to present for you. Something you want to consider is, can you hire a temporary worker to do that job? Some jobs you can, some jobs you can't. So there are variables in place that will kind of guide your decision, but you're right. You'll never know for sure whether a court will embrace the premise that it's an undue hardship or not. But the key here is get as much information as possible. Far too often employers make these decisions with far less information than they're legally entitled to.
Any other questions? Anything else you'd want to cover? Let me just reach out to some folks and see if I can talk to some people while we're here. Kathy Stansel, are you out there? I know we talked before. Do you have any questions based on the presentation?
First of all, can we get a copy of this PowerPoint?
I will send a copy of the PowerPoint and the actual recorded webinar to everyone that's registered and or requests it.
Okay, awesome. I am requesting.
Okay.
And as far as questions go, I don't think, everything was really pretty self-explanatory as the way you were covering it, which is awesome.
Ask about maternity duty coming in for live duty.
One question we do have is a police officer that is pregnant on giving her light duty assignments because she can't patrol.
All right, that brings up something known as the Pregnancy Discrimination Act, which as interpreted by the EEOC essentially forces us to treat pregnancy as if it's a disability. Under the Pregnancy Discrimination Act, if they're seeking an accommodation we have provided to a non-disabled person, then we are effectively obligated to provide that accommodation. Are we talking about nighttime? Are we talking about daytime shifts? That's typically the fact pattern I see.
Daytime, correct.
So she's usually nighttime, or she's works a shift that alternates and she wants full-time day shifts for the rest of her pregnancy, correct?
Correct.
All right.
Yes.
And so the question really is, what do we have from the doctor to support that? Do we have anything from that doctor to support that premise? And let me just back up for a second and tell you that some doctors have the belief that a woman is more likely to miscarry if she works at night or she has a fluctuating shift. So that may be the medical basis for this, but where are we in terms of documentation? Do we have anything?
I don't have anything. I don't know if the chief received anything or not. He's the one that put her on light duty.
All right. And did he do it at her request, or did he just do it because she's pregnant?
He decided that he would do it when she could no longer wear her bulletproof vest.
All right. And that's, if he's fine with that, then that's fine, I guess. But what is your question? Are you obligated to give them an accommodation?
If we've given her an accommodation for that, would we have to give another employee, not necessarily pregnant, but maybe out on illness, at the same thing, a light duty job?
Potentially, but all these fact patterns, and this is the frustrating thing, because in employment law we talk about consistency. Each of these fact patterns is different. We've got different doctors who have different theories, who are going to communicate different things to us, and the employees have different jobs. And the reality is, the police department may have a lot of people in FMLA right now, and there are a lot of openings, and maybe next year there won't be. So I can't give you a hard and fast rule, but just know this: you have to individually assess each of these fact patterns, which makes it less likely that somebody can point to someone else and say, hey, you did this for them, you need to do it for me. Because invariably there will be different variables in play. Like I said, different medical conditions, different doctors. There's just a whole lot that prevents you from an employee pointing to some other colleague and say, hey, you did that for them, do that for me.
Well, thank you guys much for your questions. You guys get a gold star today, so put that down. Anything else before we let you go?
Oh, I think we're good. Thank you.
Thank you. We do have another question here. When he mentioned leave without pay and that cannot be enforced, is that primarily with a medical related leave, or is that any type of leave request? If we have an employee that is approved for a 6-month leave, can they be held to that 6 months?
So the question is, if the employer on the front end says you're entitled to 6 months, and that 6 months expires and the employee can't come back, can we say enough is enough? No. We can maybe deny extra leave if we can prove it's an undue hardship, but we can't have a hard and fast rule of we gave you 6 months and that's all we're going to give you. It has to be based on the particular situation. Why is giving this person more than 6 months a problem? Why is it causing an undue hardship? That's how we would have to couch any kind of rejection if that person sought more unpaid leave beyond 6 months. So no, you can't make your life easier, unfortunately, by just saying, we'll give you 6 months and that's it. That's essentially a maximum leave policy.
Here's another question. I think it's related to the migraine question before. Migraine employee has gave us a note from her doctor stating she has chronic migraines. We have changed her lighting every time she is out for 3 days. Her FMLA is not migraine related. She only works 10 40-hour weeks. When should we say enough?
Well, you said, I guess she's taking FMLA leave for a non-related medical issue. That's what I ascertained. If I'm wrong, I apologize. But you can insist upon a certification from the employee relating to that totally separate and distinct medical condition. So in that situation, what you want to do is you want to label those absences FMLA absences too, to cause her to burn through her 12. It sounds like she's having her cake and eat it too. She's taking medical leave, but we're not taxing her account, in other words. If I misunderstood your question.
So the key is with that being consistent, and anytime anybody has leave, whether it's work comp or personal leave, that you're taking advantage of that FMLA? Or
Correct.
documenting that?
You don't want the employee to decide whether it's FMLA leave. It's your decision. And if somebody is taking leave that qualifies for FMLA, well, we want to make sure it's categorized as such, because they only get 12 weeks in whatever the 12-month period is you have chosen. So it sounds like we're allowing her to manage this fact pattern more than we're managing the fact pattern. To the extent she needs leave for a serious health condition, then we can most definitely label that FMLA leave and count that against her 12 weeks. So I hope we get a follow-up if I misunderstood the question, but that's how I understood it.
And again, it's extremely important to be consistent in how we deal with. So if, we start somebody immediately that goes on work comp, one person on FMLA at that same time, if another person does it and we wait 6 weeks to do it, we would potentially have an issue.
Well, luckily there's retroactive FMLA leave. If we can retroactively designate it if we miss the boat. And what happens a lot of times is someone goes out on workers' comp, we're not viewing it as an FMLA fact pattern because they did not ask for FMLA. But as soon as we know someone has a health-related reason that's causing them to miss work, under the law, we now have an obligation to process that as an FMLA fact pattern, even if the person, they don't want FMLA. We don't have a choice. We as an employer have to process that as FMLA leave because FMLA gives employees certain protections. And if we don't categorize it as FMLA leave, then we are effectively denying them the right of reinstatement. So we need to be very proactive. If we know somebody's out because of a medical reason, I don't care if they ask for FMLA. As soon as we know that they're out because of a medical reason, that triggers our obligation to send that FMLA form WH-381 and to go down all those steps in terms of FMLA.
Very good. Very good. Any more questions out there? You guys have been great. Thank you so much. A very active and energetic audience. We really much appreciate it. We won't be able to hear you, but please all stand up and give Donald a round of applause. He's done a great job. We really appreciated his time here. And I will send this all to you, the recording, the presentation, and a sample policy. So be looking forward to that. If not, thank you so very much, and we will talk later.